2 p.m. and it's time to start this meeting. And I'll push the button on so that everybody can hear me. Subsequent to our last meeting, we did receive some correspondence, including a memorandum which we were just handed. I have time to read that. Did the council members get a chance to read that as well? Yes. So, as indicated, we received a couple of letters. Both of them addressed complaints related to Deputy Mayor Kidd, which we have not begun to examine yet. And there's some items in those letters which relate to our decision last week, including Mr. Kenyon has submitted a proposal for findings and conclusions of law. Our Water, Our Choices suggested that we take further action regarding Councilman Gase. I have proposed some findings and conclusions of law as well, which were circulated, which are a little bit different, but I'd like to hear from the members of the committee as to how they want to proceed in regard to that issue.
In regard to Mr. Gase?
Yes.
Microphone.
I still don't see any reason why. Yes, it is.
Sit up.
I still don't see any reason why Mr. Gase is responsible for anything that Deputy Mayor Kidd did.
Yeah, I too feel that passivity is not one of the ethical charges we were looking at, so I stick with it.
Let me ask the committee members if you would mind if I kind of gave my personal opinion on this at some point.
Feel free.
Feel free.
Okay. So we just got handed a letter that has the line in it. I'm going to read that because I think it is worth reading. It says, this board meeting us apparently needs special training in the doctrine of fairness. And I'm going to respond to that. So here's my personal reviews. So Mr. Kenyon's submittal documents discuss the underlying fluoridation dispute as part of his proposed findings. I believe that that is not relevant in any way to this board, nor should it be. Specific allegations of individual council members' conduct violating the city ethics code have been made. This committee is required to follow the code. Under the code, we are to determine first if the alleged conduct violated the code, and second, if that conduct actually occurred. Our initial step is spelled out in the code. It's very simple if we follow the code as we are charged to do. The political dispute underlying the charges are not before us, and they must not influence our decision. I would note that challenges to someone's ethics are serious. You may call me rude, you may call me stupid, you may call me fat, you may call me ignorant, you may call me obnoxious, and I will be offended, except for the parts of those that are true. But if you call me unethical, you have in effect accused me of something akin to a crime, and I would fight you tooth and nail. That's the attitude I bring to these charges in investigating them. They are serious, and as a member of this board, I intend to follow the letter of the code specifically, and to do otherwise would be unfair to the person accused, as well as it would be unfair to the accuser. In reviewing an ethics complaint, we are directed by the code to first assume that the allegations in the complaint are absolutely true. We are then to determine if they are true, if the conduct alleged would be a violation of the code of ethics. We are not to look at additional input at that stage of our task. We are not to broaden the scope of our inquiry beyond the complaint. We did not do that. Last week what we did was look at the allegations against Councilmember Gase, and it would only be if we answered the question, yes, those allegations would constitute a violation of the code of ethics, that we would take the next step and begin to investigate if in fact those events and conduct did occur. We reviewed each of the allegations under the pertinent provision of the code and found by unanimous agreement that even if those actions alleged occurred, they would not violate the code of conduct as set forth by the City of Port Angeles. Our Water, Our Choice suggests we could not have considered a packet of materials which they provided at the beginning of the last meeting, and they are correct. We We do not consider that. The code prevents us from considering anything from the complaint at the initial review of the charges made. Our choice suggests that we need to review videotapes and testimony to determine if Councilmember Gase took some other action beyond the passive action which was alleged in the complaint. And I suppose he could have made faces or gestures of some kind, but that was not alleged in the complaint, and I suspect had he done so, the complaint would have made those allegations. It does not make those allegations. Our choice suggests that we need to determine if any council member directed notice prohibiting signs be posted because they, quote, believe it likely that some member of the city council did so. The complaint does not specifically suggest that Councilman Gase did that. If we were to expand our inquiry because of some belief that some council member did that, would we then bring all the council members into this? The complaint needs to be specific. That's fair to the party being accused. I believe that our findings regarding Councilman Gase should be brief and to the point. The first findings I drafted stated that Councilmember Gase took no actions or had no interaction with members of the public. On review, I would amend that, and I have prepared an amended one that changes that slightly to say that the complaint does not allege that he took inappropriate action other than silence. That's the procedure that's to be followed. If in fact somebody wants to allege that during the course of the meeting he did something else inappropriate than was alleged, they can file a complaint. They've got 3 years to do that. But we are required to first look at the complaint and determine if there is any basis upon which we can sustain the allegations of a violation of the Code of Ethics. And if we cannot, it is fair to the individual charged, it is fair to the group charging, and most importantly, it's fair to the citizens of Port Angeles that we dismiss it and move on. So, having said that, that's my personal opinions. I have proposed some findings and conclusions which I've handed to each of you. I would like to know, 1, whether you'd like any comment from anyone else on that, and 2, what your feelings are about the proposed findings.
I don't think I need any more comments on that, and I'm in agreement with your findings.
Yeah, I do am in agreement, and I would like to press that we, as well as we can keep politics completely out of this and not let it find its way in.
All right, so do I have a motion to adopt the findings, a second for this presented?
I make a motion.
I second it.
Moved and seconded that we adopt the findings of fact and conclusions of law which are before us. Any further discussion? All those in favor?
Aye.
I suggest we all 3 sign them and give it to the clerk. That leads us to the second issue, which are the allegations against Deputy Mayor Kidd. I would note that in the communications that we received, that first of all, there are indications that there was a decision made by the panel which was appointed prior to our panel. Secondly, in some of the correspondence, our choice asks that certain allegations which they made be withdrawn. And I think we might, frankly, address that issue first. What happens when a complainant moves to withdraw allegations? I would know we don't have legal counsel to answer that question for us, but I guess I'll ask the board, is a complainant allowed to withdraw allegations?
I understand we're breaking new ground. We set the rules once again. If they want to withdraw a complaint for equipment, you might allow it.
I don't see anything wrong with them withdrawing a complaint.
They only want to withdraw certain allegations, not the whole complaint. Ma'am, did you want to say something?
Yes, my name's Edna Bulletin, and what we withdrew it is we understood that that had already been settled by court board number 1.
Okay.
So we're not trying to step on anybody else's toes with that. And the other question I have for you is, will we be able to go to the city council with this decision on Dan Gase?
Go to the city council with.
Because they're the ones that make the ultimate choice what happens and what doesn't happen.
We have recommended dismissal, and as I read the code, the council will take a look at that.
And as long as you understand that, is we're dismissing what was already settled.
Yes, well, and I'm just saying, are we allowed to do that? Because the code's kind of silent on whether you can amend the complaint, and I do think that that has some implications.
They did allow it in the board number 1. In fact, they did allow a rewrite right on hers.
I understand that. Well, I think probably before we answer that question, maybe I'd like to go even a step further, and I would like to ask a question of the participants here, if you have no objection.
No objection.
Okay. So here's this, and I would be interested in whether the complainant believes that all of the violations raised by them before the first panel, in the complaints that were filed by that panel, were addressed either one way or another in the opinion issued last Friday.
We have no evidence that they addressed anything other than what we just said that we were withdrawing from. We have no confirmation of anything else being done except just the one. And we sat through all the hearings.
Okay. Mr. Kenyon or Ms. Deputy Mayor Kidd, do you have any information on that?
If I might, Mike Kenyon for the Deputy Mayor, we have not seen the document you're referencing that purports to withdraw certain claims. We'd like an opportunity to review that before we comment further. I think with respect to your direct question to the Deputy Mayor, it's our understanding from last Friday evening that the board number 1, for lack of a better term, did find a violation with respect to one of the allegations and exonerated her with respect to the others. But there are no written findings.
But I guess my question, did they make a finding as to the other allegations, or yea or nay, or?
There were four complaints, and they dismissed 3, and there were findings on 1. So, but that was from another complainant. That was from Mrs. Smith. This complaint that went to Ethics Board number 2 is from Our Water, Our Choice. They originate from different people, and they're worded differently. So.
Well, maybe I'm being too obtuse, so I'm just going to cut to the chase here, and it sounds like maybe we can't do any more today, in my opinion, but here's why.
So I thought you were charged with looking at the complaints that were forwarded to Ethics Committee number 2, which includes complaints against me.
Okay. So the question arose, and frankly, as we'll note here, so Our Water, Our Choice wants to withdraw 2 of the complaints which were filed in the initial complaint given to us because they were addressed to Our Water, Our Choice's satisfaction by the other panel, which means they're obviously the same conduct. And they believe that panel had authority to decide them did, and they're happy with the decision. And that's in the letter that maybe you did get a copy of. Last week, I know I told you that I couldn't believe the code would allow a second panel to consider the same allegations, and that the code had to be violation specific as opposed to complainant specific. Otherwise, you could have a complaint filed every week by another person who was offended by some action of the city council, and that frankly, while double jeopardy doesn't apply, eternal jeopardy probably is a factor we should not consider, that someone could continue to make complaints over the same conduct ad infinitum against the same individual, despite how many panels were impaneled to decide that and make recommendations. So I looked at the code to determine if it said anything on that, and I think it does. And historically, this ethics code came about for a couple of reasons, not the least of which were allegations that one member of the city council or two members were undermining the actions of another. So in the code, under section 2.78.030J, it defines public officials who it applies to. And those include the members of boards appointed by the city council, which means us. We are public officials as we sit here. And we have limited powers under the code. And under section F of PAMC 2.78.070, it says the boards of ethics appointed by the city council have limited powers. Now I'm going to quote, "The board does not have the authority to reverse or otherwise modify a prior action of a public official." First board are public officials. They have taken action, be it to dismiss the charge or to find that the charge is valid and refer it to the city council. As I read the code, we would be violating the code of ethics to reconsider that and issue a different opinion. It's the only way I can read the code that makes sense, frankly, and I understand why that would be the case. So frankly, unless there is something that they did not rule on in terms of a specific act, I don't think we have jurisdiction to do anything. Unfortunately today, I don't know exactly what they ruled on other than what I heard from our water right choice as to those two issues, which they want to withdraw, and I think frankly that whether they withdraw them or not, we can't hear them and that they've been decided one way or another. That's, again, my opinion from reading the code.
Mr. Chair, if I might, we were just handed by the acting clerk what appears to be signed findings and conclusions regarding Deputy Mayor Kidd. We don't have the signed findings regarding Councilmember Gase, nor do we yet have the document that has been described that our Water Our Choice submitted, apparently asking to withdraw certain claims. With respect to the chair's comments, the city council, the code also directs that separate boards be appointed for separate complaints, and that's what we have here. As this board knows, Board 1 heard evidence that this board is not aware of.
Yes, if we have findings as to Deputy Mayor Kidd, those should be eliminated. I meant to have the signed findings for Gase. I did prepare findings as to Deputy Mayor Kidd and what we might have after Gase. So those are signed as to Deputy Mayor Kidd, they should be decided. And I'll have us sign the proper one. I gave you the wrong one. My response to it is it's separate complaints. Read the code as a whole, and it says separate complaints. I think complaint refers to the violation, complainant, not to the complainant. Otherwise, you could have, if there was 50 members of our Water Our Choice, they could each file a complaint. We'd have to impanel 50 panels.
I think that's what that is what the code said.
If that's the case, then I would find that the code is not constitutional and that it would establish a sort of a permanent jeopardy for public officials in that case. And I don't have the right to rule that it's unconstitutional. Most of the time you look at ordinances and you try and interpret them in a fashion that would render them constitutional. And when I read this, and I read it all, it tells me that each violation gets looked at by a board, an independent board, to determine if the board believes a violation occurred, and that gets referred to the city council. And it doesn't matter how many people complain about that violation, it's the violation that gets looked at, not how many people noticed or complained about the violation. I don't see any way to harmonize the code other than that. So that's why I'm coming from. If in fact that's the findings I handed you, is that the one that says Deputy Mayor Kidd on the top?
Yes.
That should be discarded, and I'm going to ask that we sign this one, which is the proper one. I apologize for that. Okay. that puts us in a difficult situation. So, as I read the ethics complaint filed by our water, our choice, the first issue related to the notice as to signs. The second allegation related to the deputy mayor taking over the meeting while the mayor was on the telephone in violation of CCRP 7. The third violation, which consisted of interruptions of party speaking, I understand is to be withdrawn. The fourth objection was that Councilmember Lee Redden was gaveled out of order at a time when he asked for a legal opinion at the time of the first recess. The fifth allegation was that the mayor declared a 5-minute recess without giving council time to overrule the recess declaration. The sixth allegation is that the deputy mayor adjourned the meeting prior to the end of the scheduled comment period, which I understand our choice wants to withdraw. And the seventh, that the council did not allow time for the council to overrule the decision to adjourn. I don't know if that would be subsumed in your withdrawal of the adjournment issue or not, frankly. But if we allow the other two to be withdrawn, then we are left with those issues, and I question whether or not they were resolved by the first council, or whether or not this committee wants to consider whether or not we should investigate those further. Or wait till we get more information and written findings from the first panel. Is that something you wrote up? This is something I wrote up. I went through and tried to.
Okay, I got it from the side, the same thing. Came up with 8.
Any thoughts on how we proceed?
I'm surprised that we don't have an attorney for you, because the email that I had received from the city said that we would have one at this meeting. So put you-
Apparently that did not occur.
Put you in a bind.
How many violations do you have written down?
I had 7.
I came up with 8. But some of it, I think we did fix.
If we have jurisdiction to hear all of the complaint filed against us, then the first question is, must we consider all of the complaint filed against us, or do we allow withdrawal by the complainant of certain actions? I think we talked a little bit about that. My feeling is, that, again, it would make no sense to require an investigation of a withdrawn complaint.
I would agree.
On the other hand, if the city council wanted us to review the complaints and give us perhaps a different opinion, then allowing it to be withdrawn would not make sense. If that's the city council's intent, or the intent of the ordinance. Again, I don't think that's the intent of the ordinance personally, but that's where we are. The code suggests that we then look at the complaints and determine that, if true, would they constitute violations? And if true, the allegations would constitute violations of the city code of ethics. At that point in time, would we determine what sort of investigation we would wish to make to determine whether or not those allegations are in fact true. In fact.
We should go into meeting and discuss this.
My only concern is that the code also suggests this be done in a public meeting, and I'm kind of hesitant to do anything in private until we get to our final deliberations. And at this point, we're only talking process.
Well, yeah, we need to figure out exactly what we need to do before we start anything.
Well, my opinion, and again, it's my opinion, I don't frankly want to overrule the members of the board, but my opinion is until we know exactly what the first committee did, if in fact we are looking at determining we don't have jurisdiction to redo what they did, then we can know what they did before we determine if there's anything left for us to consider. I don't know, we don't have anyone here from that committee. I don't know if we have any indication of when their findings might be.
I'm sorry, sir, I can't hear you.
I'm sorry. I don't know if we have any indication of when the first committee's
They're
final
meeting-
findings.
They'll meet tomorrow at 10 o'clock for private deliberations. It's been noticed to the public. They will not take action, but we'll know from that meeting when they will, and they'll do that in a public meeting.
Right, thank you.
Well, I think the first thing we need to do is come down with the definites on the charges. You have said them written down there.
Maybe it would be useful if we went through and made sure that we were all on the same page as to what the allegations in the current complaint are, as they relate to
That's where
their
we're at right now.
And I wrote it in chronological order as I read through this. So why don't we just start and we'll see. The first was the notice disallowing signs for one purpose or another. And the second chronological issue would be that the deputy mayor took the meeting despite the mayor being available by telephone. The third one I wrote down was that Mr. Johnson was interrupted during his time of speaking. The fourth one I wrote down was that Councilmember Lee Wethen was gavelled out of order when he asked for a legal opinion. The fifth one that I wrote was that a 5-minute recess was declared without giving council time to overrule the recess declaration. The sixth one I wrote was that the meeting was adjourned prior to the end of the scheduled comment period. And the seventh one I wrote was that the deputy mayor did not allow time for the council to overrule the decision to adjourn. You said you had an additional one?
Well, with the paragraphs, between each paragraph, must have been a complaint.
Well, I had 8, because my 8th one was about Mr. Gase, but
Oh, okay.
everybody asked, our water, our choice, are those the allegations that were raised?
I followed them down, yes.
Are there any others that, where I missed?
No, but I would suggest that we possibly consider getting an attorney here because it puts everybody in a position to where we don't know what we can and can't do. And we're back and forth and back and forth.
I agree that I think the issue on how we proceed is, in some respects, a legal one. And while I certainly have some experience in legal issues, I'm not sure that I should be the one giving legal opinions to this board.
And the other, you're waiting for the findings back, what they had covered, what they have not covered.
All right, so members of the committee, how do you want to proceed?
I make a motion that we adjourn until we either get an attorney or get the results of the other ethics committee.
I would amend that to both. Not either.
Okay, well,
All right, we have a motion and a second that we adjourn until we get both an attorney to represent us, which the code requires or suggests, and that we get the findings from the initial board. Do we have any idea on a timetable on either of those? At this point, we probably don't.
I won't know until the meeting tomorrow when they plan to meet next.
How long would it take to give appropriate notice of a public meeting for our next meeting following the receipt of that information?
You need to notice the meeting 24 hours before the meeting.
So it could be noted relatively quickly. All right. I'm always reluctant, frankly, to adjourn a meeting without having another one scheduled, but I don't know that we can do that.
Mr. Williams?
Yes.
I will be out of town for a week starting next Tuesday.
Okay. We can tentatively set a meeting in 2 weeks, and hopefully we would have things available at that point in time, if that works.
What time is it Tuesday? Carol?
I'm not
19th.
seeking to unnecessarily delay, but I'll be out that following week, Tuesday through Friday.
Tuesday through Friday.
So 2 weeks, that what I mean?
The week of the 25th.
And I just want to verify, do we have any time limit on this that we have to have it completed?
The code suggests that the matter be completed within 60 days.
Well, we're getting close.
Yes. So you filed February 19th, so, and it was the long February this year, so we're looking at the 21st. Probably looking at the 21st of April, which would be the 60 days.
Those 2 weeks we can't meet prior. What happens if you can't meet prior?
Well, that's obviously a dilemma. Might I suggest if we meet on the 21st, I do not anticipate that the action we would take on the 21st would depend on the legal opinion and on the material submitted by the first panel. That action may be to find we don't have jurisdiction and we're done, or the action would be we do have jurisdiction or any of the alleged violations such that we need to investigate further. I don't know that we need necessarily any input from other entities to make those decisions. So Mr. Kennedy may be gone. Again, we're at that point where input's not really necessary for us to decide whether we have to proceed further other than legal input. I mean, I'm happy to just adjourn and then have the meeting set by some sort of conference call or whatever in the interim, but it strikes me it might be good to have another day.
21st, because we need not to read on the 14th. And we want to do it because it doesn't make a difference which one.
I'm not available on the 14th, and I don't know if we'll have the next meeting because
Yeah, okay. You're kind of important to be in there.
but I am available on the 21st if that works, which is a Thursday. There was a preference date given for these meetings, and we kind of overruled that.
No, it wasn't me, it was the 21st because of my mom having a stroke and commitments out of town, but I'm starting to override those things, so we could start meeting, that's why I suggested Tuesday, which would be the 19th.
And I'm available on the 19th.
I'm available as well.
I'm available with the only exception that I need to be in Sequim at 5 o'clock for board meeting.
We have to be at 2 o'clock.
No.
Okay, we should.
Is there a time on Tuesday other than 2 that would be?
With them?
Just other than, is there any reason we need to meet at 2 as opposed to 1 or 9 or
10.
10?
If I could have a moment to check the council calendar.
Certainly, thank you.
I have a question while she's out.
Yes.
Mr. Yucha mentioned to me today that the video from February 2nd, that the voices are not tracking right. Would you think it inappropriate for me to repost that video?
I wasn't saying they weren't tracking right, but
Okay.
I just was trying to allude to they seem to pick up a little echo and a lot of background noise in contrast to these recordings.
Oh, sure.
Are extremely clear. That's all.
Okay, thank you.
I guess to answer your question, that to the extent that that makes it easier for us to view that video, and that's a video that we ultimately want to view, then I have no problem with that, so.
Okay, I'll check it.
Yes.
We have a council meeting that evening, a possible executive session at 5, but the day is free. So you can set the time.
10 o'clock.
10 o'clock?
10 o'clock works, that's the 19th.
April 19th?
April 19th at 10 a.m.
Buddy said he's not here.
All right, any other business that we want to take care of today, or that we can take care of today?
None that I'm aware of.
All right. All right, then, again, there was a motion to adjourn. Any further discussion on that?
I have one more question.
Yes, ma'am.
Did we make sure that the city is going to get us an attorney here?
It's my understanding that our motion, in effect, is us requesting a city attorney, or an attorney be appointed to give us legal advice. I'm assuming that will be reported. I know there was discussion earlier before the last meeting that they would attempt to get someone to give us that advice. So I sort of expected someone might be here today, but apparently not. So, you want to make that a formal request, or do you think that sort of subsumed in our motion?
I'll include the minutes.
Okay. All right, thank you. So we will get